The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, this is Heather Jones, a family law attorney with O'Flaherty Law, and today we're doing a how-to video for filling out Form FA-4128VA, the Affidavit to Show Cause and Request for Hearing for Temporary Order with Minor Children. This video is for educational purposes only. It is not meant to be legal advice. It is not a good idea if you're having a lot of serious issues with your family law case to go it on your own. We strongly suggest that you consult with a experienced Wisconsin family law attorney if you're running into trouble you can't handle. But this video is meant to just walk you through the form and explain some of the finer points of it and how to just have a good form filled out so you make things as easy as possible on yourself moving forward. So we'll just start at the top of the form. This is a form for people who have either solely or jointly petitioned for divorce. So at the top left-hand corner of the page, you're going to put your name and your spouse's name, and you can be petitioner or joint petitioner, respondent or joint petitioner. It just depends on what kind of petition you filed. Then you're going to put the county that you filed your petition for divorce in. This top right-hand corner, you should probably know by now, don't go there. This area belongs to the clerk of courts, and that's where they do their file stamp magic. So don't write anything here. Don't write anything in the upper hand corner. Don't staple it up here. If perhaps you, for some odd reason, want to staple things at the wrong side of the paper, just leave it alone. That's not for you. Then you'll fill out the names and the captions in regard to the marriage of, and then you don't have to circle this or anything. Just the petitioner or joint petitioner A. Doesn't matter if you're joint petitioner A or B. Just pick one and stick with it throughout the proceeding. Petitioner and respondent, name, address, city, state, and zip. Over here on the right, you'll see the title of the document, and you'll see the two different kinds of cases it can be used for. Now, typically, this is used in a divorce case because people are disagreeing on things. But sometimes you can use it in a legal separation, which we've noted in several of our how-to videos is not the same as a divorce. So that is why you have the option here for picking one of the two. Since your case has already been started and is active, you will have a case number already for your divorce action or for your legal separation, and you'll just put that here. Just make very sure it's clear and easy to read. So that takes care of the caption. Then we'll move on to kind of the meat of the affidavit. So just to give you some context, so you have a better understanding of why you would use this document in your divorce proceeding or in your legal separation. The title really tells you what's going on. So this is an affidavit, and anytime you see the word affidavit, think sworn statement, because you're swearing to the truth of this document, the things that you are saying within it. And then you're asking the other party to show cause. So especially if there's already a temporary order in place and the other party is not adhering to that order, in Wisconsin we do an affidavit in hearing to show cause why you would not be held in contempt, or to show some kind of reason why there's a change that needs to be made. And when you ask the court to make changes or to create an order, you have to ask for a hearing. So you request a hearing. And then because the divorce is still, you would use this form while the divorce is still pending, you're not going to get a final order. You're going to get a temporary order until either another temporary order has to be entered or your final decree of divorce with your marital settlement agreement and your custody agreement and your visitation plan and all those good things are included with it. So really, you're asking for the court to step in and make decisions and compel people to do things while the divorce is still pending. And you're using this form because there are minor children involved. So that opens up a lot more issues than if they're not. So with that understanding, we'll move to kind of the meat of the document here. And you'll say, 1, the other party and I have not agreed on a temporary arrangement while this action is pending, and there is a need for such an order. So a lot of times people go to mediation pretty early on in the divorce, and they come to some arrangements, at least temporary arrangements, where, they say, okay, the kids are going to be with you Monday through Friday afternoon. I get them Friday afternoon through Sunday evening. That typical kind of arrangement. Or, we agree that on Friday afternoon, instead of the kids coming home on the bus, you will pick them up at school and they will just go to your place for the weekend. That kind of thing. Or that you will pay me $300 a month so that I can make the mortgage payment on the marital home while the divorce is pending. Things of that nature. And it's just not happening, or it never was agreed on and you need the court to step in and set some things up so that you can continue with life during the divorce, so that you can sort of just take care of business, pay your bills, make sure your kids are where they're supposed to be, that each parent is getting adequate time if that is a safe thing, that sort of deal. So in number 2, you say, I request that a hearing be held and a temporary order, always remember it's temporary, be entered concerning one or more of the following issues. And here's where we get into the real nitty-gritty. So, legal custody and physical placement. Who gets a say over what happens with the kids and where are they most of the time? Child support goes without saying. You've got to do it. Maintenance. Not always an issue, but could be an issue if one spouse wasn't working and didn't have any education or skills or a job. The court could order temporary maintenance, maybe even permanent maintenance, depending on the facts of each situation. Use of the residence, aka the marital home, and other property, for example, the cottage up north. Payment of debts and financial obligations. So everybody's got debts, and if the debt came into being during the marriage, it's a marital debt, and you're both at least at first considered responsible for it. So it's usually helpful if there's a mortgage, a car loan, some other kind of personal loan that needs to be paid every month. You've got to work that all out. They still have to be paid while the divorce is moving forward. Payment of insurance and healthcare expenses. This is especially important when you have young children. You need to have some kind of an agreement in place while the divorce is pending. Who's going to take care of health insurance for the kids? Who's going to take care of their trips to the dentist? Who's going to make sure that if something happens, that the children are covered? So that's a very important issue. Then you always just say, other relief that the court believes appropriate. It may be that you have, once you get into the courtroom and tell the judge everything that's going on, the judge might order something in addition. It really just depends on your individual situation. So H is other relief as follows. This is your chance to really tell in depth your side of the story. And you're probably going to need more than 2 lines for that, and they know that, and that's why the see attached box is here. So with the court forms that you get off the Wisconsin website, every single one of them has a warning. Don't modify the form, and they mean it. These forms are formatted in a very specific way. They have been designed to be acceptable to both the Wisconsin online e-filing system and in person. So if you need more room, what you do is you just put it on a separate sheet or sheets of paper and just hit see attached, and just attach it to your affidavit. That's just fine. Also, since this is your space to give your side of the story, kind of make your case, I would recommend, just as a common sense issue, to use whatever evidence you have. If there are, for instance, screenshots of text messages between you and spouse regarding visitation, or pickups and drop-offs, or they were paying maintenance and they decided to stop paying maintenance, stuff like that. Copies of bills, copies of insurance bills, anything you have to show why what you're asking for should be granted. Make a copy of it and attach it. The last thing you want is to go into court with just your word against theirs. It's very difficult, even for someone as experienced as a judge, to sit and look at like a 10-page narrative as to why the other spouse is a terrible person and they need to give you everything you ask for, without something else for the court to hang its hat on. So if you want to win, you're going to need to provide some evidence. And written evidence that's not your own words, something like a bill, something like an email, something like a screenshot of a text conversation. Those are the things that are just very solid as far as showing your side of the story and why you should get the relief that you are asking the court for. So don't just dash a few lines off and send it in. Really think it through, because you're making an argument here. You're asking the court for relief. You need to tell it why. If you require reasonable accommodations due to a disability to participate in the court process, please call blank. So whatever county that you're filing in, they probably have the number available to you on their website. It's the number any party would call if they require accommodation in the courtroom. That could be some kind of listening device. That could be something to help with their vision, those types of things. So if you need that, the number is typically on the website, but if you can't find it, just call the courthouse and they'll give you the number. But, put that number in there. You might already have it from when you did your summons, because it should have been on the summons that you filed with your petition or your joint petition. So again, as the title tells you, this is an affidavit. What's an affidavit? It's a sworn statement. And a warning. It's a sworn statement. So don't say anything untrue or you're committing perjury. If you don't know, say you don't know. If it's your opinion and not a fact, say it's your opinion. Don't say, don't lead the court to believe it's a fact. Just be scrupulously honest. And if you don't know something, that's okay. Say that, because that way you're still being honest. So this is the big deal. Here's the stop sign. Take this document to a notary public before you sign it. It's tough for me to understand as an attorney how people would sign it and then take it to a notary and expect it to be stamped, but that is just the world I live in. Don't sign it until the notary looks at the document and confirms your ID. And then sign it in front of the notary and they'll stamp it for you. If you are worried about finding a notary, you can probably find one at your bank or credit union and they'll notarize it for you for free. I've had that work for me really well before. Otherwise, I know the UPS store will do it for about $5, and that's not such a big deal. But just don't sign it until the notary has met with you, seen the document, and examined your ID, and they like to write it down in their little books. So no signing without a notary on this one. And again, as we discussed earlier in the video, don't modify the form. It can be supplemented with additional material. You can supplement to your heart's content. Don't modify the form. Don't get fancy with Adobe. Because I know some type A personalities out there might be like, well, I'm great with Adobe, so I'm just going to put more lines in and have it all look nice and neat. Don't do it. Leave the format the way it is. And that, in a very small nutshell, is the affidavit to show cause and request for hearing for temporary order with minor children here in the great state of Wisconsin. Thank you so much for watching. If you'd like to learn more about divorce in Wisconsin, you can visit our page. It's linked below. And be sure to leave any questions you have in the comments section and subscribe for more legal content daily. And I wish you the best of luck in your case.
Hi again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed the video and podcast. If you did, I'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please don't hesitate to reach out to schedule a consultation. Most consultations are free and can be conducted remotely if you'd like. You can email us, book online, or call us at 414-253-2080. That's 414-253-2080. We have many locations for your convenience and we serve all of Wisconsin. Thanks again for watching.